I would like to welcome you in joining us to this virtual book launch of National Commissions of Inquiry in Africa, Vehicles to Pursue Accountability for Violations of the Right to Life, edited by Thomas Probert and Christof Heyns. I would like to briefly give an overview of the event program and some basic house rules. This event is structured as follows. I will make some welcoming remarks, and Professor Frans Viljoen will pay tribute to the late Professor Christof Heyns. Our speakers, whom I shall introduce prior to their contributions, will address us on core concepts and ideas explored in this edited volume. We are joined today by Thomas Probert, one of the editors and contributing author of the volume, two of those contributing authors, in fact, Mitali Jain and Anyango Yvonne Uyeke, as well as Justice Kate Oregan. Each speaker will address us for approximately 10 minutes. Please hold on to your questions or type them in the chat box, as there will be a question and answer session during which you may ask those questions inspired by National Commissions of Inquiry in Africa to our panel of speakers. You can either type your question in the chat box, or you can use the raise hand function in the action panel below. PULP will then conduct a poll, and finally, I shall offer some concluding remarks and notes of thank you on behalf of the editors. I would kindly ask our audience to keep their microphones on mute to prevent any disturbances, and to please use the raise hand function during the question and answer session. The raise hand function can be found in the Reactions tab in the toolbar, which is located at the bottom of your screen. In the same toolbar, you can find the Chat tab, which will allow you to type your question into the chat box. Please ensure that you address your question to everyone. You can see if this setting is checked at the bottom of the chat box. I now turn to some preliminary welcome remarks. Unfortunately, due to his untimely passing, the late Professor Heyns, who edited this publication with Thomas, cannot be with us today, but I'm sure he would undoubtedly have wanted us to celebrate the actualization of this important and impactful project, which forms part of his lasting legacy. I cite the words of Solomon Ayele Dershu, chairman of the African Commission on Human and People's Rights, on the value of this contribution. I quote, "The insights it offers on why, how, and when commissions of inquiry in Africa facilitate accountability are profoundly informative, not only for scholars, but also for policymakers and practitioners," end of quote. Furthermore, I'm also sure that Professor Heyns and his family would be grateful to see so many friends and colleagues contributing to and attending this event. Justice Oregan, I'm sure Christof would especially have appreciated your participation today. National Commissions of Inquiry in Africa asks how and to what extent National Commissions of Inquiry can contribute towards accountability for potentially unlawful death, thereby protecting the right to life, specifically in the African context. This book explores the actions African states can take to better fulfill their duties, to pursue accountability, including by investigating potentially unlawful deaths. After establishing the importance of accountability processes for the protection of the right to life and the standards according to which they may be evaluated, the volume focuses on a particular mechanism, namely the National Commission of Inquiry. As will become clear, this is a mechanism widely and regularly used on the African continent, but one that has received surprisingly scant academic attention. This book makes a valuable contribution to filling this lacuna. The focus in the book specifically is on the procedural component of the right to life, the element of accountability. When I hear the term the right to life, I recall fond memories of the year 2013 when I first met both Christof and Thomas. It is no secret that during the golden age of international law at the University of Pretoria, many of us flocked to UP to learn from the larger-than-life Professor Heyns. I was one of those students. And back in 2013, I recall Professor Heyns included a few of us very fortunate postgraduate students to join his Monday afternoon sessions on different aspects of the right to life. This was during the time when he was Special Rapporteur on extraordinary, summary, or arbitrary executions. Professor Heyns and Dr. Probert challenged us with thought-provoking multidisciplinary challenges concerning the right to life, and I recall how Professor Heyns listened to all our suggestions and thoughts, even though we were but mere students. I recall how he and Thomas engaged us on the potential of commissions of inquiry, as well as legal questions following the Marikana massacre. Christof always made time in his busy schedule for those Monday discussions. I shared those memories with Thomas and asked him when exactly the seed was planted to pursue this book project. Thomas, who will elaborate on this more extensively, shared the idea that their interest in commissions of inquiry was picked from the early days of their work revising the Minnesota Protocol, the original version of which had included an extensive section dedicated to commissions. This was also at the time when South Africa had experienced two prominent commissions of inquiry related to right to life issues, the Marikana Commission, before which Christof gave expert evidence, and where several members of his team participated in various capacities, and the Khayelitsha Commission, about which Justin Oregan is likely to say more. I would now like to hand the floor to Professor Frans Viljoen, Director of the Center of Human Rights at the University of Pretoria and fellow PULP member, to commemorate the late Professor Heyns, after which I shall introduce our panel in turn.
Thank you very much, Marty, moderator. I think our launch today brings into focus two of Christof's abiding passions, which I will briefly speak to. The first is his passion for publishing. And I think it was not publishing for the sake of just having another publication. It was publishing to expand, to disseminate, to reach ever increasingly wider audiences. And I think this passion of Christof is embedded in his great generosity of spirit, in his sharing nature. I think Christof lived and he worked expansively. He thought and he operated in ways that were always inclusive of as many people as possible. For him, it was to multiply multitudes was what he was aspiring to do. Many things, I think, gave Christof great joy and pleasure. Now, one of them certainly was the bringing to life of PULP and the nurturing of it. And I think specifically because PULP stood for open access dissemination of legal text across the African continent, in addition to cultivating scholarship among African scholars. The second abiding passion is that towards the right to life, which underlies many of the commissions of inquiry that we're looking at in this book. And I think, again, it was not just to conceptualize and think about what this right means, but it was about the rights holders. There are few ways in which human rights defenders' basic humanity are touched as by the infringement of their right to life. Clearly, the concept of vulnerability is given heightened accentuation in the context of threats to one's right to life. And I think, again, here it is Christof's deep sense of humanity, his spirit of Ubuntu, that impelled him, in a sense, towards a career, a professional career that cultivated his intellectual thinking through the lens of the right to life. The first inroad to this was as UN Special Rapporteur on extrajudicial summary and arbitrary executions and killings. That position he held, as I think many of us know, from 2010 for 2 terms until 2016. Then came the membership of the Human Rights Committee from 2017 to 2020, and the right in particular around peaceful assemblies, which again had a particular link to the right to life. Within the African context, there was the work with the working group of the African Commission on the Right to Life, and perhaps most relevant to us today, his leadership role in the UN independent investigation on Burundi. In all these respects, his passion for the right to life shone through. And I think the book that we ponder about today is a fruit of these two passions, a fruit of Christof's labor of love. There's a lot for us to savor in this moment, but there is certainly much that will transcend even today. Thank you very much.
Thank you so much, Frans. I wish to invite Thomas Probert for a brief discussion of the background to the book. Thomas is an extraordinary lecturer at the Center for Human Rights. From 2013 to 2016, he was a research consultant to the UN Special Rapporteur on extrajudicial, summary, or arbitrary executions, partly based in the Office of the High Commission for Human Rights in Geneva. Thereafter, Thomas continued to work closely with Professor Heyns, supporting his work both with the UN Human Rights Committee and the African Commission on Human and People's Rights. He is also a research associate of the Center of Governance and Human Rights at the University of Cambridge. Thomas will introduce the nexus between that work and the project underlying the book on accountability for violations of the right to life. Thomas, the floor is yours.
Thank you very much, Marty, and it's a great pleasure to be with you all today, albeit virtually, to celebrate this publication, which, as you rather intimated, Marty, in those introductory remarks, is a fruit of quite a long labour, and it's a great pleasure also to be able to reconnect with some of those who participated at various stages of the research building up to it. It was a book that we published online in the middle of last year, and so it's a great pleasure and relief that Christof did see the culmination of this book. I don't think he was ever, unfortunately, able to lay his hands physically on a hard copy of it, but he did see the printing of the book. But it is, of course, also an event that's tinged with sadness in that regard. And thank you also to Frans for those remarks, to which I might just add a couple of reflections on how the book, I think, plays up certain dimensions of Christof's legacy, or my experiences of working with Christof. Two in particular, firstly, the collegiality of the way in which he worked, and Yvonne and Matali will recall the research design meeting that had to presumptively be moved from campus to Christof's own living room in 2016 because of Fees Must Fall. We were about to go into the field in Kenya for the first time, and really needed to finalize these research questions. And Christof and his family immediately and hospitably took us all in to be able to finalize this project. But also the diversity of the team itself was, I think, a reflection of the commitment that Christof always had to ensuring that the work that he was doing at the United Nations could intersect with so many different parts of the university's research agenda. And this book forms part of a broader university project that was investigating the role that Ubuntu and other traditional African value systems play in contemporary African politics and society, and the way in which he was able to design a research project that both fulfilled, I think, an important role in the context of his UN work in a way that I'll go on to discuss now, but that also had this, I think, really valuable theoretical and academic question underpinning it. It was very much the essence of the dual life that Christof lived. The right to life, as Franz remarked, was the central kind of normative tenet of that life and of our work together. And I think Christof always preferred to frame his mandate around that concept rather than using this cumbersome and often misunderstood title, extrajudicial, summary, or arbitrary executions. And the right to life, of course, has those two core dimensions. Firstly, the substantive prohibition on arbitrary deprivation of life, but also an equally important procedural dimension, that there must be accountability processes where a death, potentially unlawful death, has occurred. And so accountability played this central part, really, in how Christof undertook the work of both the mandate and I think subsequently the approach that was taken both in the general comment on peaceful assembly that Franz mentioned, but also the contribution that he made earlier in his term on the Human Rights Committee to the general comment on the right to life. And the purpose, I think, for Christof and for all of us around how accountability contributes to the human rights project at large is, I think, really how it turns a right from what he would sometimes refer to as the soft understanding of a right, like an aspiration, to the strong understanding of a right, namely that there must be some kind of consequence that follows from a violation of it. And accountability requires the answering of a number of vital questions in the aftermath of such a violation. And of course, this applies in general to any human right, but with respect to the right to life, I think those questions are broadly, what happened, who suffered and how, who was responsible, how can the suffering or the loss or the disruption to the norm be repaired or compensated, potentially including through prosecutions if that's appropriate, and critically, how can the same situation, the same violation be prevented from occurring again in the future? All of those questions form part of a meaningful accountability process, and I think that trying to ensure that such processes followed allegations of violations of the right to life was the recurring work of Christof as mandate holder at the time that we were conceiving of this project, and investigations, those factual questions, I think, were foremost in our minds when thinking about this project, because despite that normative framing as a mandate about the right to life, I think we were both aware of the fact that this isn't a subject area where debate about the substantive norms, certainly at the international level, is really the name of the game. This mandate is always going to be more about facts. Whether or not a death occurred, whether or not the state was involved in the death, and if both of those two things are there, whether the specific facts of the circumstances in which the death took place lead to a conclusion that the death was arbitrary. And all of those are factually dependent questions, which frontlines the issue of investigations and how you establish those facts. And a document that was central in that process of setting standards around what those investigations look like, Marty mentioned the Minnesota Protocol, what was formerly the UN Manual on the Prevention and Investigation of Extralegal, Arbitrary and Summary Executions, but which became known as the Minnesota Protocol because of the role of this group of civil society forensic scientists who, during the 1980s, played a role in conjunction with various UN bodies in bringing together what at that point was the kind of sum of knowledge around what an effective death investigation looked like. And quite early in his mandate, I think on a country visit to India, Christof was confronted by a forensic pathologist who pointed out to him that this manual was still the gold standard, but that there were certain kind of shortcomings to conducting a death investigation in the 2010s from a manual that had been written in the 1980s. From a scientific point of view, clearly that was written in a time before DNA evidence, before digital photography, before a number of practical evolutions in the way that these investigations take place. But there were also, I think, important legal developments that had taken place since the time of that drafting. And one of the characteristics, peculiarities of the original document was that it had this extended section on national commissions of inquiry as some kind of default or even preferable mechanism of investigation when a potentially unlawful death has occurred. And I think that question, in conjunction with the South African context that Marty identified, and of course commissions of inquiry occurring elsewhere around the world, led to us asking this question of, well, is there a reason why commissions of inquiry should have this preferential treatment, given that there is also certain anecdotal impression that this can be quite a weak investigative mechanism, that it can become a smokescreen behind which powerful hegemonic political interests effectively achieve impunity for violations. And so that question essentially was what drove this research project, coming in conjunction, as I remarked earlier, with an opportunity to engage in this multidisciplinary research project at the university around the role of traditional values, because it occurred to us at the time that commissions of inquiry, these kind of extraordinary ad hoc quasi-judicial mechanisms that don't necessarily produce binding findings, but that nonetheless can speak with considerable authority. And the question is then prompted, well, what is the ground for that authority? Where does it come from? And it seemed, perhaps going slightly further back into South African history of commissions of inquiry and the Truth and Reconciliation Commission, that part of the justification of that kind of authority may be some kind of grounding in traditional customary values, and that at the very least, the idea of an ad hoc mechanism wherever in the world it's established creates the opportunity for such value systems to be reflected in the way in which the mechanism is designed, or in the way in which it's able to hear from participants, be they victims or other stakeholders. And so those two questions were really the two that lie at the heart of this project. So I won't say too much about how the book has unfolded. I think we're going to hear from fellow chapter authors and participants in this long process, both about the kind of background of how commissions are used and one of the 6 case studies. But perhaps just briefly to situate that conversation, we looked at a kind of 25-year period from 1990 to 2015 and tried exhaustively to survey those national commissions of inquiry that had taken place in Africa that had some kind of bearing on a right to life question. So by no means all commissions of inquiry, just those that looked at the right to life as an issue, and found more than 60 of them. Which we list in an annex to the book for those who are interested. But of those 60, we then chose just 6 to engage in these further, far more detailed inquiries, sending researchers to the countries involved, or in one case where the Extraordinary African Chambers had also and was at the same time examining a relevant question, also went to the seat of that chamber in Senegal, and spoke really to as many people as we could find with some kind of connection to the commission, and our gratitude again to Justice Oregan for making herself available to our research endeavors some time ago now in that connection. Yvonne is going to describe the Nigerian example later, and Justice Oregan will likely reflect upon her experience with the South African. But just to introduce the other four very briefly, we looked at the Commission of Inquiry into the long-term abuses of Isenabre in Chad. So a commission that took place in a kind of transitional context. We looked at a far more specific incident in Burkina Faso, where a prominent journalist and critic of the government, Norbert Zongo, was killed in very suspicious circumstances that led to a commission of inquiry. We looked at arguably one of the more significant commissions of inquiry in terms of the development of standards in the aftermath in Kenya, the commission that likely inspired Philip Alston's influential report into standard setting around commissions of inquiry, and that of course also had an interesting afterlife in the process before the ICC, and the Commission of Inquiry in Malawi that examined policing response in connection with a mass demonstration, kind of linking with another of Christof's interests, as Franz alluded to, the policing of demonstrations. So we looked at these 6 examples and effectively came away with the conclusion that there is certainly a role that these bodies can play in accountability processes, that they can make a substantial contribution, either towards subsequent eventual criminal accountability, but not necessarily, and it's no invalidation of their purpose if they don't, but that because they can also contribute by way of that recognition and restoration of a norm in the aftermath of a violation, going back to that broader purpose of accountability, publicly demonstrating that life is valuable, and that taking it has consequences that make societies pause and reflect upon what has happened. But we also established that in a number of cases that potential positive role isn't actually achieved, that for a variety of reasons, commissions are not well structured or well executed. And I think probably the example that Yvonne will discuss a little later is the strongest example in the book of that. And so I think broadly the book is making a case that we don't necessarily need more of these inquiries, but that we do need better ones, and perhaps in the aftermath of the 3 following presentations, we can get into during the Q&A a discussion of what those might look like. But I'll stop there and pass back to you. Thank you very much, Martin.
Thank you so much for sharing those insights and also setting the scene for our other contributors or panelists. I would now like to invite Mtsali Jain to offer some introductory remarks on the longer history of the use of commissions of inquiry during colonial administrations in Africa and elsewhere. And Mtsali Jain is an international human rights lawyer who has worked as a senior researcher with the Institute for International and Comparative Law in Africa at the University of Pretoria and the Center for Applied Legal Studies at the University of Witwatersrand. She also founded the Constitutional Literacy and Service Initiative, which is very inspiring, a South African human rights education organization. She has practiced in the fields of human and civil rights, Immigration and Criminal Defence, and previously clerked for judges of the Constitutional Court of South Africa and the United States District Court in California. In addition to the early work of designing the research project underlying this book, she authored the chapter on the Khayelitsha Commission of Inquiry and the chapter examining the historical use of commissions across Africa and around the world, which will be the topic of her presentation today. Mitsali, the floor is yours.
Thank you, Marti, and thank you to the Center for Human Rights for inviting me to join you today. It's a real pleasure to see this come to fruition, this book coming into fruition, and to be in conversation with all of you. I have to say it's quite sad also to be here without Christof joining us, since this really was his vision, but I'm pleased that his legacy is codified in this book for many generations to come and for many around the world to read. So thank you to the Center for Human Rights for hosting this. As Marti said, this chapter that I'm going to speak about now really was designed to situate modern day national commissions of inquiry, historically, colonially, politically, in order to better understand their potential and limitations. And of course, as one might expect, the colonial legacy of domestic commissions of inquiries is one in which these commissions were looked at suspiciously as instruments of colonial states to consolidate and augment their power. And while our research found that there was great truth in that in many instances, what we also learned were several examples of national commissions of inquiry that actually defied popular perception. And they were able to assemble a modicum of independence, to critique colonial rule, and frankly, sometimes even were able to catalyze, albeit ever so small, policy reform within colonial administrations. And certainly within the English-speaking world, the lineage of national commissions of inquiry dates back to the 11th century. And so we looked at that a bit. In the non-English speaking world, the tradition is less dated, but still quite robust. And today's modern African states often have relied on their power to establish commissions of inquiry as part of their accountability apparatus. And this stems directly from the colonial legacy, in which commissions often represented an external imposition of a quasi-juridical mechanism in the colonies to legitimate foreign colonization. These commissions also often had an ethnological dimension to them and were used to explore the terms, as I said previously, on which state power could be consolidated and reproduced. One of the interesting post-colonial legacies of commissions is that governance in former colonies became heavily dependent on this language of law. And so some analysts have commented on the use of the word lawfare, namely the use of a coercive legal tactic to dominate colonized people, as one that became very standard in former colonies. These commissions of inquiries were legal mechanisms that legitimated state control. And so we see the legacy of that today in terms of the very heavy language of law that exists to describe and explore these commissions of inquiry. And all of this was equally true in most of the world and in colonial Africa. In this chapter, we looked at case studies specifically from French, Belgian, and British rule. While many commissions did serve to legitimate the colonial state, there were those that disrupted the course of colonial rule. And it also interesting kind of examination was that in South Africa alone, between 1910 and 2015, there were 45 commissions of inquiry dedicated to some aspect of policing. So there is quite a robust historical legacy of these commissions throughout Africa. Just to kind of flag one interesting case study that we look at in the chapter, it was one of the ABA Commission of Inquiry of 1929 in the Igbo region of eastern Nigeria. The colonial government had manufactured a chieftaincy institution in an area that did not have that tradition. And so this led to a very widespread women's revolt, protesting this system of designating certain local representatives as chiefs in order to spread colonial rule. And the women's revolt resulted in much violence. And it was that violence that led to the establishment of the ABA Commission to investigate the remote and immediate causes of this women's movement. It sat in over 30 locations to collect evidence, which was quite profound. There were 485 witnesses from whom testimonies were collected. It does bear mention, however, that not even 25% of these witnesses were women. But ultimately, the chieftaincy system was abolished, and there were urgent reforms instituted based on indigenous systems from the Igbo region. And so that's just one example of a National Commission of Inquiry that perhaps didn't follow the usual script of consolidating and reproducing colonial rule as it was, but actually disrupted it. And today, Nigeria, South Africa, and Kenya feature National Commissions of Inquiry as a regular institution of accountability, and in fact came to independence with statutes on the books to be able to establish these commissions of inquiries. I think Thomas previously spoke about the numbers that we found as part of this study, which were approximately 70 national commissions of inquiry established throughout Africa between 1990 and 2016 to investigate violations of the right to life. And of those 70 commissions examined, about approximately 45 were traditional commissions of inquiry and 25 were truth commissions, which of course are a variant of a traditional commission of inquiry. And so 48 of those commissions were constituted in Anglophone countries, about 20 in Francophone countries, and 2 in Lusophone or Hispanophone countries. And so this really does, I think, reflect the dominance of commissions of inquiry within the common law tradition. But again, not at all insignificant that it is a feature in Francophone countries as well. Nigeria really has led on the African continent with 12 national commissions in the last 25 years. Now, mind you, these numbers are a bit dated because they go through 2016, followed by South Africa and Zambia. And commissions of inquiry do overall seem to be becoming more common, although that might also reflect that there's increased information available about commissions of inquiry in more recent years. I'm going to leave it there. I think there's a lot within this chapter to unpack. And the case studies, I think, are actually the richest site of exploration of the features and circumstances in which commissions were able to deviate from the traditional perception of commissions of inquiry as being simple instruments of colonial rule. So I encourage you to read this chapter and of course all the other chapters as well, but this one I think does help to situate the later discussion of the more modern commissions of inquiry. So thanks once again for inviting me to be here, and I'll turn it back to Marti.
Thank you so much, Mtsali, for that very rich discussion. I'm sure that our audience is very excited to read the chapter if they have not yet done so. We now turn to Anyango Yvonne Uyeke, who is a lecturer in the Department of Public Law at the University of Nairobi School of Law. She wrote both an LLM and LLD at the University of Pretoria in the Department of Jurisprudence on the development of a post-apartheid jurisprudence. Her research interests include gender and women's studies, transitional justice, and critical legal feminist and race theories. Like Mitali, Yvonne played a central role in the research team whose work has culminated in this book. She participated in 4 of the 6 country research visits, ultimately authoring 2 of the chapters on the Waki Commission looking into post-election violence in Kenya, and the topic of her presentation today, the Kaduna State Commission of Inquiry into the killings at Zaria in 2015. Yvonne, the virtual floor is yours.
Thank you, Marty, and thank you to the Center for Human Rights for putting this together, and PULP for seeing through a project that Christof was very passionate about. And I'm certainly very honored to have been a part of it, right from inception through to the point we are now, where we're launching a true labor of love, I think. So today, I'll just give some brief reflections on one of the commissions of inquiry that are studied in detail in this book, which is the Commission of Inquiry looking at the clashes between the Islamic movement Nigeria and the Nigerian army. As Mitali has mentioned, I think all of the case studies are really very interesting, and the different issues that they bring to the fore about commissions of inquiry along the areas of study that we identified for this study specifically are all very interesting. But this specific commission of inquiry we thought was particularly unique for a series of reasons that I will get into shortly, and certainly offered a lot of lessons when it comes to the potential for commissions of inquiry in securing accountability based on the peculiarities that this specific commission of inquiry noted. So this commission of inquiry is one in a long record of commissions of inquiry in Nigeria, as mentioned by Mitali. And in the way that most of the commissions of inquiry focusing on a specific issue of the right to life in Nigeria does, it focused on an ethnic or ethno-religious conflict. So one of the many reasons this specific commission of inquiry is interesting is because in the first instance, after the completion of the process, the facts still remain in contention. Unlike most of the other commissions of inquiry that we looked at, establishing the facts didn't really seem to be problematic or contentious, as there seemed to be a lot of agreement in that respect. But due to certain fundamental flaws, if you will, or fundamental challenges when it came to the constitution of this specific commission of inquiry, the facts remain in contention. So the official version, as recounted by the commission's report, was not very thorough. If you compare to the other versions on the same set of facts that have come forward, including, for example, after an investigation that was carried out by Amnesty International on the same issue. And the reason for this is linked to several possibilities, but the ones that we flag in this specific instance are, unlike the other commissions of inquiry that we investigated, one of the parties that was central to this inquiry were missing, and that's the Islamic movement Nigeria. And another instance that accounts for the lack of clarity on the facts is the failure by the commission to use all of the powers that were available to it. But overall, what we can say with certainty about what happened during that period, looking at the different version of events, is that between the 12th to the 14th of December 2015, there were clashes between the Islamic movement Nigeria and the Nigerian army in Zaria, which is the headquarters of the Islamic movement Nigeria. And this, it's been, according to what we've been able to find, is due to some roadblocks that were put up by the Islamic movement Nigeria, and the failure to provide access to the chief of army staff of the Nigerian army, or he wasn't allowed passage. So what resulted from that specific instance is what remains in contention, because the official version does not give much detail as compared to the information that comes forward with Amnesty International's version. Another interesting aspect that came out of this specific commission was issues around effectiveness. I think one of the grounds, or one of the areas that we focused on with respect to commissions of inquiry was how effective they were. And one of the questions we asked in that respect was, are they independent? Are they impartial? Most of the commissions of inquiry that we dealt with had a certain level of independence and largely seemed to be impartial. However, this specific commission of inquiry really did struggle with the question of impartiality, especially because there were allegations that were put forward by the Islamic movement in Nigeria. And this is the basis on which they chose to not participate in the proceedings of the Commission of Inquiry, which had a snowball effect ultimately on the findings and the recommendations, the impact and the uptake of those specific recommendations. But some of the commissioners who were brought on, or who were confirmed as part of the team, had made public utterances against the Islamic movement Nigeria. And this is highlighted in detail in the chapter, so I won't go into it here. But there were also questions on impartiality around the terms of reference of the Commission of Inquiry, because they were expanded after the initial gazettement to include a focus on the origins and dealings of the Islamic movement Nigeria. And some of the participants that we spoke with, including representatives from the Islamic movement Nigeria and civil society, mentioned that some of those terms of reference did seem to allude to a lack of impartiality. It seemed almost a fait accompli, and it seemed a decision had already been made about the culpability of the different parties. And it's on this reason that the Islamic movement Nigeria did not participate in the Commission of Inquiry. That in and of itself was not a problem, because one party absent to the proceedings certainly does place a higher burden on those who participate to ensure that the results and the outcomes are as objective as possible. However, this leads to another issue that we thought was interesting and certainly worth highlighting, which was the selective use of the Commission's powers. Because in the absence of one of the parties, it would have been important for the Commission to take all the steps necessary to ensure that the facts as presented to them by one party were actually verifiable and true. However, the Commission, for example, chose to not rely on forensic evidence, which is a power that is granted to them by the National Act or on commissions of inquiry, and I think certainly by the Kaduna government enabling legislation. However, they chose not to rely on forensic evidence. And this means, for example, they weren't able to ascertain the actual number of deaths that resulted during that time, because the report that came from the Nigerian army was about 10 or 12 deaths at the most. But there was on record a witness who actually cited the presence of a mass grave, which means that the number of deaths were probably over 300. So that discrepancy is something that could have easily been resolved through the use of forensic evidence. So their decision to not rely on forensic evidence in full use of the powers that they have available to them was an interesting choice, and we argue problematic to the extent that there is a section of the narrative that is missing from this specific commission's report, and it's therefore a little bit one-sided. The other aspect that was really interesting with this specific commission was the fact that there were several competing mechanisms that were instituted at the same time. So alongside this specific commission of inquiry, there was an investigation by the National Human Rights Commission, and there was also a parallel investigation that was undertaken by the Nigerian Army. Full details are available in the chapter. But of all of these processes, this commission of inquiry was actually the last in terms of chronology. So there are a lot of questions that were raised around why the Kaduna government chose to institute a whole different process, why it didn't subject itself to the two other mechanisms that were already in existence. And even though the decision to institute a commission of inquiry is one that's well within the rights of the commission, there could have been greater coordination between these three different mechanisms to ensure that there were no gaps or certain things didn't fall in the cracks on the assumption that, you know, all of these different mechanisms were looking into it. So I think those are just a few of the instances that make this specific commission of inquiry unique and a little bit different to the other commissions of inquiry. Because as you will see, if you read the specific chapters, the other commissions of inquiry don't have as much contention around their impartiality, and they don't have as much contention around the use of their powers. And there's not as much contention around the various competing mechanisms, that there seems to be a better coordination between all of these different processes. So despite the one-sided nature of the outcomes of this commission, mainly due to the lack of participation by the Islamic movement Nigeria and the failure on the part of the commission, perhaps to use its powers to, in the first instance, rely on forensic evidence. Another instance, for example, was its failure to compel the government to produce the leader of the IMN, who was detained shortly after that commission. And his detention was one of the reasons that the Islamic movement didn't participate in the proceedings. So that was a power that was well within their mandate, a subpoena for the appearance of the leader of the Islamic movement Nigeria, which would have solved their problem in terms of the IMN's involvement. But you know, that was a decision that was intentionally made, which had an impact on the outcomes of the report, and ultimately the impact and the acceptance by the government. But despite this, in its peculiarity, it still offers some useful information that I think is worth thinking about or highlighting when it comes to the role of commissions of inquiry in securing accountability, and I think especially highlighting the multifaceted nature of securing accountability in a space like this, because there's often an assumption that for a commission of inquiry to be effective, then, or to have the relevant impact, then you look through to the eventual outcomes and the extent to which it's able to shift something in the policy or the broader legal or social sphere. this commission of inquiry perhaps taught us something else. What it was able to do in the first instance was, in the context of Nigeria, to highlight through its findings the excessive use of force by the Nigerian army in the first instance. And that's something that can definitely be taken up in future. It also raised questions on the use of the armed forces as law enforcement, because that is the role that the army played in that specific context. If you look at the facts of the case of the commission as presented in this case study, the use of the armed forces as law enforcement, certainly something worth exploring. It also highlighted the importance of a perception of impartiality and the independence of a commission in its effectiveness. The presence of the IMN may not have had an impact on the outcomes of the commission. They may well have come to the same results, but the fact that they were not deemed to be impartial had an impact on its effectiveness, to the extent that the outcomes weren't considered legitimate. And therefore, the processes that followed certainly didn't have the uptick in the impact that I think it could have. It highlighted the need for a coordinated approach between different mechanisms. So the decision to have these different mechanisms is not problematic in and of itself, but certainly there's a need across federal and across state lines to work a little bit coordinated to ensure that certain aspects don't fall within the cracks. And it also highlighted, that several factors render a commission impactful. So depending on the circumstances, these must be adequately balanced. So a commission of inquiry will be, or its impact will be felt along the different scales. And in some instances, there may not be prosecutions that follow, but that doesn't mean that in that specific instance, there's no sense of accountability, because it's on various scales, and there's a need to balance based on context. And finally, to the extent that it contributed to national and international debate around accountability is notable, and maybe a function of commissions to consider. So just the fact that it offered a space for debate and deliberation on the meaning of certain principles, certain democratic principles, including around accountability, is something that is also noteworthy in this specific instance, and certainly worth thinking about when discussing commissions of inquiry. So I will leave it there.
Thank you so much, Yvonne, for this thought-provoking introduction of the Zaria Commission. I can see already in the chat box that the attendees and the audience are eager to read this chapter. Thank you so much. Finally, I have the privilege of introducing Justice Oregan to offer some wider reflections upon the potential role commissions of inquiry can play within systems of accountability. Justice Kate Oregan served as one of the founding judges of the Constitutional Court of South Africa from 1994 to 2009, writing several of the court's most influential decisions. She currently is the inaugural director of the Bonavero Institute of Human Rights at the University of Oxford. Of particular relevance to today's conversation, from 2013 to 2014, Justice Oregan served as a commissioner in the Khayelitsha Commission of Inquiry into Policing, one of the case studies reviewed in the book. Unlike the Zaria Commission that Yvonne mentioned, and indeed the other examples considered in the book, the Khayelitsha Commission was an example of the use of a commission of inquiry to address systemic issues by highlighting patterns of action, or rather inaction, over time. In addition to this direct experience, during her time on the bench, Justice Oregan will have observed numerous commissions of inquiry into salient legal questions, and so seems extremely well placed to comment generally upon both good and bad practices with respect to commissions and the role they can play within broader systems of accountability. Justice, thank you so much for joining us. The virtual floor is yours.
Thank you very much for that very warm introduction, Marti, and it's a great pleasure to be joining Thomas and Mitali and Yvonne on this panel. Although, of course, a very sad occasion because Christof can't be here to talk about the book of which he has been one of the joint editors. And I was pleased to hear Frans speaking about Christof at the outset. And just to add, my deep sadness and of the Bonavera Institute as well, where Christof was one of the members of our advisory council. He was a giant of a human rights lawyer of whom all of us in Africa should be very proud, and whose departure leaves some very big footprints to be filled. I would also like to really congratulate the authors and editors on this book. It's the first one I'm aware of that has looked at commissions of inquiry across the continent of Africa, and not only picked out 6 specific commissions to look at closely, but also looked at them. Mitali talked about the sort of overall history in her chapter and again today, and looking at it not only in the parts of Africa that fell under the British Empire, but also looking at it in terms of French and Belgian empires and the role that commissions played in our history. The book contains also a very useful reflection by Christof on this question of social solidarity in Africa and how commissions might fit into our thinking about social solidarity. So it's a really interesting book, which I warmly recommend to everybody. As requested, I'm going to start and talk a little bit, however, about commissions of inquiry, or thinking about commissions of inquiry, perhaps as you would if you were a potential commissioner, or as if you were a potential person who wanted to make representations to a commission. And I think the first thing is to recognize that nearly in every case, commissions of inquiry are processes to provide advice to the executive. They're nearly always appointed by the executive, and they nearly always report to the executive. I see in the chat there's some conversation as well about truth commissions. Well, some truth commissions are appointed in that way, and some truth commissions are appointed differently. But I think that when one thinks about commissions of inquiry, it's important to realize that they're effectively a tool of the executive, a tool of executive government. We're sometimes misled about this a bit, because very often, and again, we see this in the specific commissions referred to here, very often judges are appointed to lead commissions of inquiry, and one could think then, well, this is some sort of a judicial exercise. But judges are appointed very often, I think, because the executive wants some non-partisan people to lead the commission or to be on the commission, rather than people who are seen as part of the political parties and part of the political process. But it means when you realize that really that a commission is in fact a tool of the executive, if one's approached as a judge, one's got to think very carefully about whether you will do it or not. And indeed, in some jurisdictions, there have been arguments made that in fact it's quite inappropriate for judges to chair commissions of inquiry. And I think that there are certain requirements that if a judge is going to chair a commission of inquiry, that should be conditions upon which the judge will agree to do so. And the first is that I think the judge needs to scrutinize the terms of reference very carefully to make sure that what is being asked is an appropriate investigation for a judge who must be impartial and independent and must behave in such a manner. And one wants to make sure that the terms of reference, that the matter that you're being asked to investigate is suitable to be investigated by a judge. So things that are of a particularly party political character, for example, probably something judges would want to avoid, because very difficult in circumstances where potentially the executive is using the tool of a commission of inquiry for party political purposes. That could be that could draw the judge into an kind of an abuse of power in a sense. So one needs to think very closely about what the terms of reference are. Secondly, I think one needs to think very carefully about process, because one of the things that we expect of the legal process, and in some ways judges are the core guardians of this, is that the process must be fair. So one wants to make sure that both in the terms of reference and in the governing legislation or regulations around the commission of inquiry, it is possible to ensure that the commission acts in a fair manner. And then thirdly, and I think this is very important, is I think that people who preside over commissions of inquiry, particularly judges when they preside over commissions of inquiry, but perhaps everybody, should be clear in their minds about the fact that the report of the inquiry will be public. There are commissions of inquiry, and indeed it's raised in the chapter on the Nigerian commission of inquiry that Yvonne spoke about a moment ago, where the executive requests that the results or the report of the commission not be published, and it remains in the hands of the executive as to whether it will be or not. Now, the difficulty with that is that in terms of the accountability of the judge or the person providing over the commission of inquiry, in a sense, the legitimacy of their work and their accountability is no longer in their hands. So again, I think one needs to be very cautious in accepting a position on a commission of inquiry where there are any conditions imposed upon the publication of the report. So that's the first thing to think about, that commissions of inquiry really are a tool of the executive, and that if one wants to participate in them, one needs to think very carefully about the conditions upon which one is going to participate. Secondly, I've talked a little bit about the terms of reference, but this seems to me to be very important because it's the terms of reference which determine, as it were, what the commission should do, must do, but also only may do, because they are, as it were, the jurisdiction, to use a lawyer's language, of the commission. And I think it's quite open to people who approach to chair a commission inquiry to have a debate with the appointing power about what the terms of the commission may be. And coupled with what the terms are is the time frame. Again, we see this in some of the commissions of inquiry investigated in this book. Sometimes commissions are under very tight timeframes, and one would want to match the time frame to the terms of reference. You can't do, as it were, an enormous write a doctoral thesis in 3 months. You have to do something that is manageable. So it's important to look at those questions. By and large, the terms of reference nearly always require a process of fact-finding. In most commissions of inquiry, and I think without exception, well, perhaps with only one exception amongst the 6 here, the investigation is about fact-finding, and it needs to be clear to what it is that is what has to be found out. And I think some thought needs to be given as to how you might go about finding that out. But then in addition to fact-finding, there's normally a provision for recommendations. And those are generally non-binding recommendations that are made to the executive, and the executive, of course, may accept them or not accept them. But those recommendations will generally be based on the facts as found. I think it's important to recognize that there sometimes is a tension between the fact-finding exercise of a commission and potential civil and criminal adjudication that may follow. I mean, we've watched it a little bit in the State Capture Commission in South Africa, where the commission is tasked with finding out whether there has been criminal malfeasance in relation to state capture. And we know that they may well result in criminal prosecutions in due course. This is a very delicate matter for the commission to handle, and needs to be thought through quite carefully. Another issue that might arise, and it's interesting, it arose in 2 of the cases in the book, is the question of the relationship within a federal state or a multi-tiered state between whoever is appointing the commission, whether it's the federal or national government or the state government, and various and the allocation of powers, constitutional allocation of powers between them. So again, Yvonne spoke about this in relation to Kaduna State in Nigeria, in relation to the clash between the Islamic movement of Nigeria and the Nigerian army. And a similar issue arose in the Kailicha Commission, where I was one of the commissioners, between the Western Cape government, which had appointed the Commission of Inquiry, and the national government, who has overarching responsibility for policing. So these can cause particular difficulties, I think, for both commissioners and parties before a commission. So the last two bits about thinking about commissions that I wanted to talk about is the process and the reporting. So the process, it seems to me, needs to be carefully thought through. Who has a right or should have a right to appear before the commission? Identifying the parties who may want to lead evidence before the commission is a very important part of the commission's processing. And it by and large, if you want the commission to be seen as legitimate, excluding people who appear to have a specific interest may well cause difficulties. And that was an issue that arose, again, covered in this book, in the Kenyan Commission of Inquiry into the electoral violence in the 2007 elections in Kenya, where two political parties were excluded, although the leaders of the parties were permitted to testify and lead evidence before the commission. And another quite common problem is when the commission is boycotted by somebody who clearly has an interest but who does not want to appear. So you've got people who the commission excludes who might want to appear, but you also have the problem of people who ought to appear, but who for some reason or another don't want to appear. And today, of course, in South Africa, we've had this enormously important judgment of the Constitutional Court in relation to former President Zuma's refusal to appear before the State Capture Commission. This is a particularly difficult problem for a commission. It was an issue in the Kailicha Commission. Those of you who have read the book or know about the commission will know that initially the police, who were one of to be investigated effectively, the question the commission had to consider was whether there were inefficiencies in policing in Kailicha and whether there was a breakdown in the relationship between the community of Kailicha and the police in Kailicha, did not want to cooperate with the commission. And the commission had to issue a subpoena, and the issue of the subpoena led to the establishment of the commission and its terms of reference being challenged by the police. And that case went all the way to South Africa's Constitutional Court, where the police case was dismissed. That didn't mean the police were going to cooperate particularly well, but as it happened, after, I think, some quite kind of careful work on behalf of the commission and its evidence leaders, we actually ended up with pretty full cooperation from the police, despite that rather unpromising start. But this is really an ongoing problem for commissions, is ensuring that they have the right people before them and that they get full disclosure. And of course, then the other part of this is about ensuring that ordinary people too can feel that they have a right to come before the commission and put their version before the commission, and that they are heard and treated equally and with due respect. And again, this can involve locating the commission, because if a commission of inquiry is concerned with events that happen in one place and the commission might hold its hearings 1,000 kilometers away somewhere else, that will almost certainly prejudice those people who might like otherwise to come and testify before the commission, or at least participate in its hearings. Of course, we now know that with the advance of Zoom and the online world, perhaps location will not be as much of a barrier as it has been in the past. But there is something very valuable about having the commission in the place where people who are most interested in its work are able to attend easily. So all of these are kind of considerations that go into fair process. Another big issue in Africa will be language. What language should the commission operate in, and how should it manage the fact that people who are here appearing before the commission may speak different languages? Finally, reporting. I think reporting, of course, is a very important part of the accountability of commissions themselves. If commissions may be a tool of holding others accountable, they themselves need to be accountable. and ensuring that their reporting is accessible, clear, thorough, balanced, fair, is all part of the project of commissions of inquiry. So in conclusion, it may well be true that as tools of the executive, commissions of inquiry have at times been used to avoid accountability, to muddy the waters, to delay accountability. They are also potentially tools of accountability. And I think thinking carefully through what the questions being asked of the Commission, who are appropriately before the Commission, what the process should be, and what the reporting and recommendations should be, can make it easier for commissions to ensure that there are tools of accountability, not mechanisms for avoiding accountability, and that they themselves too are accountable. Thanks very much, Marti.
Thank you so much, Justice Oregan, for these thought-provoking remarks and reflections, and for also contextualizing today's decision. I will now like to open the floor for questions, and we don't have a lot of time, but I have used my position as chair to collect some of the questions from the chat box. I will now ask a first round of questions. Justice Oregan, William asked, in your experience of the commissions of inquiry on the African continent, has it been independent and impartial, or has some of these indeed been stained by governmental influence? And is there a measure of transparency, perhaps, to prevent this? Then the next question, while I give you a moment to reflect on this question, I would also like to pose the question raised by Daniel Kiwi for Mitali and Thomas. Do we see a difference between a commission of inquiry and the Truth of Reconciliation Commission? Is it necessary for there to be a difference? And is that the concern of its enforceability? Justice Oregan, when you are ready.
Thank you, Marty, and thank you to William and to the other people who put the questions. So the question of whether commissions are independent and impartial is a very important one, and it's difficult to answer in the abstract. I think that many commissions are. I think it is possible, and Mitali's fascinating account of the history really makes me want to go back and do some more reading of it. But it is quite possible that commissions in the past weren't independent and impartial. I think the real challenge, though, is to recognize that there are not very many people who get up in the morning and think, I'm going to go off and do something and not be impartial and not be independent. People are a kind of product of their own experience. So probably during the imperial colonial period, the people who were chairing commissions of inquiry just didn't have the imagination to realize that perhaps they were not being impartial. It's one of the reasons why I think diversity is so important in the composition of benches, but also in the composition of commissioners on a commission of inquiry. I think the real challenge for commissions of inquiry is perhaps less about being independent and impartial. It's more about thinking through the process and making sure the process works. It requires almost a science of the process or a craft of the process, because it's quite easy for the process to become too long, to miss the point, to get bogged down. One of the difficulties is to keep reminding ourselves that in most commissions of inquiry, this is not a civil court or a criminal court. You don't have to make every single finding a fact. You don't have to afford people who participate in it the right to be presumed innocent, because you're not going to be making any convictions. There may be circumstances where they can refuse to answer questions in circumstances where those questions can't be used against them in other proceedings. But at the end of the day, this is an inquiry. It's not a courtroom. And I think one of the things lawyers find very difficult is to be flexible enough to recognize that different processes require different responses and different processes. And I think commissioners are very important in that. Evidence leaders, so most commissions of inquiry will have evidence leaders who lead the evidence, need to be very alert to that. They need to think about, what is this evidence that I'm going to lead doing? How is it going to inform the report? How much detail do I need? Similarly, the right to cross-examine seems to me to be something we, in the Khayelitsha Commission, we said there isn't an automatic right to cross-examine. You may apply to cross-examine. We will consider whether we will let you or not, but we're not going to let cross-examination turn this into a long-winded process when we're not making findings of fact. So I think quite a lot of what you'd want people who are chairing commissions of inquiry to do is to think about what the process should be that will fit the job that they're doing, and not just assume that the usual process that courts follow in civil and criminal trials is appropriate for commissions of inquiry. So that's just one thought in response to William's really interesting question. And then into the question about commissions of inquiry and truth commissions. Again, one needs to start from the terms of reference. What is this Truth Commission doing? You know, in South Africa, of course, our Truth Commission did several things. It had an amnesty committee in which people had to apply for amnesty. They had to lead evidence as to what they'd done. They had to provide full and complete account of that. And if they did that, they were entitled to amnesty. Now, that seems to me to be much closer to a civil proceeding in which it was perfectly legitimate, and it did happen, for families to cross-examine perpetrators who were seeking amnesty to make sure that there had been full and complete disclosure of the crimes for which they were seeking amnesty. But the other part of the Truth and Reconciliation Commission, which was led by Archbishop Tutu and Alex Borain and other commissioners, was less about determining the facts. It was about getting an overview of what had happened during the apartheid period. And there were not going to be findings made against individuals. That seemed to me a very different sort of process. But that's not unlike what the Khayelitsha Commission was. It was also not making findings of fact. So there will be times that commissions of inquiry and truth commissions, in terms of what they're actually doing, will be very similar, and also where their social and political significance will be similar. So I think that you can't say there's one sort of truth commission. We know there are many different types, and looking closely at their legislative provisions and at their terms of reference will be very important. And much is the same of commissions of inquiry.
Thank you so much. Thomas, would you like to respond to Daniel's question?
Yes, thank you, and thank you also to Justice Oregan for those very well the insights that come with experience in these regards, which I think are valuable to all of us. I mean, I think that I would wholly endorse the that latter part of the answer in terms of Daniel's question, that these that commissions of inquiry and truth commissions are clearly part of the same kind of genus, and they share in many instances some of the same characteristics. I think when one's thinking of those broader forms of accountability beyond the investigation, of remedy and of recommendations for reform, there are perhaps more commonalities than there are on the narrow fact-finding investigative dimension of accountability, as Justice Oregan just remarked. Clearly, the part of remedy that is recommendations regarding criminal prosecution can be a departure point between the two of them. The chapter in the book that Christof authored on social solidarity does, I think, wrestle with that question and with the question of whether the granting of immunity for potentially an international crime is something that can be accepted within the terms of reference of a commission of inquiry, and I think was really wrestling himself. One of the features of Christof's work of never being satisfied with his own drafting, which I'm sure is endlessly frustrating to those PULP colleagues on the call. But that he I think we really did wrestle with throughout this project, and the example of the TRC in South Africa is a challenging one in that regard. But I think that, practically speaking, and certainly when looking at the methods of investigation and the role that the Commission can play in allowing participation from victims, of providing memorialization of violations of the past, and providing a departure point for a society to move forward. In those regards, there are similarities between these two bodies. I'd just like to pick up a really interesting reflection of what Justice Oregan was saying with respect to the potential judge being asked to reflect upon the terms of inquiry, the terms of reference of an inquiry, was an angle that I hadn't really thought about myself before. It was certainly one of the things that we identified, the opportunity of civil society to engage with the terms of reference as early as possible, and to try to, where necessary, to conduct advocacy around terms of reference. The example of the Commission in Burkina Faso was a particularly striking example of this, where the executive came forward with a proposal for what a commission of inquiry would look like, and civil society, broadly conceived, responded very vociferously and very quickly to make clear that that vision of what a commission of inquiry would look like would not be satisfactory. And in the end, the executive had to step back and say, okay, made a number of compromises, and I think ultimately what turned out to be a more effective commission was devised as a result of that early engagement. And so the role of a variety of stakeholders, including potential commissioners, in designing the terms of reference of these commissions is clearly very important. And just to add to the reflection of those potential variables of independence and impartiality, in addition to the personality of the commissioners, I think it's also important to highlight questions such as budgetary constraints, and issues of investigatory powers that also touch on independence. So, often commissions of inquiry will have to rely upon the same forensic services, some of the same, the security services may themselves be involved in providing security for the commissioners when they are in the field. The question of witness protection, all of those questions can implicate the pre-existing state service, as it were, which in some instances is one of the potential parties to the issue in front of the commission. And those kind of operational challenges to the independence and impartiality of the commission, and the perception of the independence and impartiality of the commission, are really critically important to think about when designing these terms of reference.
Thank you so much, Thomas. As we are running slightly over time, but I do not want to end without at least asking one or so more questions, if that is okay. And those of you that has to leave, we completely understand. Thank you for joining us. I just saw that there's a basic tendency or some interest in if there's evidence if commissions of inquiry has actually served a preventative purpose, and have they perhaps persuaded, or the consequences of that is to prevent the commission of further crimes. Have you encountered this in the research? And perhaps also there was a question about views on the increased judicialization of commissions of inquiry in Africa. So I will give the panelists, perhaps yourself, Justice Oregan and Yvonne, if you want to respond, 1 minute each to do a quick round robin of final remarks for our audience. Thank you so much.
Sorry, so I'll take a stab at the question of prevention. And I mean, interestingly, of course, as I mentioned right at the start, that this was linked to the UN principles on the prevention and investigation of extralegal executions, those two dimensions are, I think, centrally linked in our thinking around how these rights are implemented. The idea that an effective investigation into an event in the past will have some kind of self-reinforcing influence into the future. That's a very difficult thing to demonstrate empirically. So perhaps all we can point to are some of the examples of recommendations that were implemented. One of the advantages of the Commission as an investigative mechanism is that it can pose these kind of forward-looking recommendations as well. The example of Malawi and the reforms to the policing service of Malawi in the aftermath of the findings of the Commission of Inquiry there. As that chapter illustrates, it was by no means a perfect Commission of Inquiry, but I think that many of the recommendations that it's made have subsequently, partly because of very effective advocacy by civil society, both in Malawi and outside of Malawi, on the basis of those recommendations, but reforms have certainly been implemented. So that's just one example, but I think we highlight many others in the book.
Justice Oregan, any final remarks? Apologies, you are muted.
Sorry, I think I'm unmuting myself and you're unmuting me at the same time. Sorry about that. I did speak a little bit about judicialization when I spoke. I do think it is a risk that lawyers and judges run, that we tend to think that the best process for everything is the one with which we're most familiar, and that is not always the case. And I think it's important to think through process. And I also think it's important for judges to think through whether they should be chairing a particular Commission of Inquiry, given that they have a duty generally to uphold the impartiality and independence of their office. And inevitably, they are lending some sense of independence and impartiality to the Commission by accepting an instruction, but I don't think it's inappropriate as long as they feel that they can act in that way. And then the last question that was put in the chat was about whether governments can appoint commissions of inquiry into things in which they are involved. Well, obviously, governments are often involved in many things, and they ought to be, because they are, at the end of the day, governing. I think there's a difference between government involvement and political party involvement, and I think it's quite important to distinguish those. So if a government were to introduce a commission of inquiry just to investigate the opposition, I would be quite anxious about that. So you would want to make sure that if there is any investigation into the political process, it's even-handed, and it may be even-handed if you want to do an independent and impartial job. But the task of government, I do think commissions can help government in their work, and it's not inappropriate for governments to seek to appoint a commission where they want a public, transparent and fair process to investigate a problem to which they must respond.
Thank you so much. Yvonne, would you like to make final remarks in about 1 minute?
Sorry. Thanks, Marty. I think I align myself with the comments that have been given before me. Maybe just to mention with respect to the Commission of Inquiry into the Post-Election Violence, the WACI Commission, I think there's a lot of focus that has been paid on that has been focused on the investigations and the prosecutions that didn't follow in the aftermath of that particular Commission of Inquiry. But if you look at the chapter, you will see that accountability as defined is quite broad, and to the extent that it piggybacked on reforms that were already underway, it did make some sort of a contribution in a broader social sense in ensuring that things that weren't particularly grounded in a specific history were now understood within the correct context. And there have been a series of reforms that have resulted from that specific Commission of Inquiry. That's highlighting the fact that accountability manifests itself in a series of ways. But once again, I just say, look at the book, and I think it highlights a little bit more some of the answers to the questions that were raised.
Thank you so much. I will now ask the audience to please participate in the Pretoria University Law Press poll. There are 10 questions, and then you will see that it concerns both this virtual book launch as well as the book itself. I will give you a moment to complete that, and after that brief moment, I will make some final remarks. Thank you. I would also like to mention that one of the advantages, or perhaps one of the great initiatives of PULP, is indeed that the books on offer are freely downloadable. So you are welcome to go to the PULP website, where you can get your very own soft copy of this contribution. And it is open access. So I'm sure that we are all very excited to, if you have not yet done so, get your copy of National Commissions of Inquiry in Africa, Vehicles to Pursue Accountability for Violations of the Right to Life, edited by Thomas Probert and Christof Heyns. You will also see that the link has been posted in the chat box. So you can actually, after you completed the poll, you are most welcome to also download a copy if you have not yet done so. So I would like to offer some final remarks. On behalf of Pretoria University Law Press and Thomas Probert, I wish to extend a warm thank you to our panelists for their enriching and thought-provoking contributions. Thank you also for staying over time to answer those very interesting questions raised, especially Justice Oregan. We really appreciate your time. I would also like to thank, and this is a big thank you, to the anonymous peer reviewers who gave up their time and whose contributions invariably materially improved each chapter. It is indeed the invisible labor that is often not recognized enough. So thank you so much to our peer reviewers. I would also like to a special word of thanks to the PULP team, specifically Lizette Herman, Yolanda Boyson and Liesel Hager for putting this event together. Thank you also to our very engaging audience. You really kept the panelists on their toes. We hope you enjoy reading and using this manual and critical evaluation of commissions of inquiry. And this is but a small but lasting part, an important part also of Christof's legacy. And we are so thankful that you could share in the book launch of this edition that I am sure will make a great impact in how we view and how in future we establish and create national commissions of inquiry. Thank you so much to all for attending. Be safe, wear your masks, and do visit our PULP website. Thank you so much, and good evening, good afternoon, and good day. Goodbye.